Mrs. Williams bought a second-hand car for her son. She thought she was buying a 1948 Morris Saloon. The registration book seemed to confirm that the car was first registered in 1948. Her son drove the car for some time and often gave lifts to their neighbour, who happened to be a car salesman. Eventually, though, he decided to upgrade it for a new Hillman Minx. His mate agreed to accept the 1948 Morris as a trade-in and gave him $290 for it. The salesman checked the registration book but did not inspect the compliance plates on the chassis. Months later, the car yard discovered that it was not in fact a 1948 Morris, but a 1939 Morris. The chassis was the same, but the older car was worth much less. They sued for the difference. The question here was one of construction. Was Williams offering to sell a 1948 Morris, or was he merely offering to sell his car, which he thought was a 1948 Morris? If it was the first of these, then he had breached the contract. If it was the second of these, then he had not. Lord Denning formed this view. What is the proper inference from the known facts? It must have been obvious to both that the seller had himself no personal knowledge of the year when the car was made. He only became owner after a great number of changes. He must have been relying on the registration book. It is unlikely that such a person would warrant the year of manufacture. The most he would do is to state his belief and then produce the registration book in verification of it. In these circumstances, the intelligent bystander would, I suggest, say that the seller did not intend to bind himself so as to warrant that it was a 1948 model. If the seller was asked to pledge himself to it, he would at once have said, I cannot do that. I have only the logbook to go by, the same as you. In other words, the seller was not guaranteeing that the car was a 1948 model. It was an innocent misrepresentation in circumstances where the dealer had the greater knowledge and could have checked the chassis immediately, but did not. Had the dealer discovered the mistake earlier, they could have rescinded the contract, but by now it was far too late.